critical. Joseph Story. Joseph Story, I don't know if you know this guy's story. This guy's an idiot savant. At the age of 30, in there somewhere, he's already a Supreme Court Justice of the United States. Skillfully, like just, this guy was an equity wizard at 30 years old. John Norton Pomeroy, another one. If you really want to get your head wrapped around mortgages, things of this nature, Pomeroy. And again, all these gentlemen, they have, I'm going to say a dozen books each that are all this thick. So you could literally drown in material and substance just reading those few authors right there. Then there's Waters, Snell, again, the list goes on. It's ridiculous how much jurisprudence is actually hiding in the background once you go do a little bit of Googling to find these things. So anyway, from this particular book that I'm pulling from, just to pull some of these segments and these zooms together, this is some of the outlines and some of the materials that these authors are referring to. And now, again, I've compared them to all these other authors, and I kind of mix and mash these things together, and I kind of come up with these little, I don't want to call them templates, but they're kind of just the nuts and bolts that we're going to use to lay down this bill in Chancery. Because again, without this bill in Chancery, without this petition, we're not going very far, very quick. Now, again, that statement is not to discredit others' efforts, such as another good friend, Mark Christopher, who is, again, another gentleman that's continually putting stuff out there as much as he can. He's really got the postal system cornered with David Wynn Miller, his processes. Again, these are gentlemen that have been doing this stuff for a long time, like myself. And without discrediting the efforts of these gentlemen, take bits and pieces, get yourself versed in a lot of stuff. I don't use a lot of parse syntax language. I'm not an expert in it. I'm going to focus on what it is that I'm doing and I'm knowing, and let's just see where I get this to with your help and others, of course. Let those gentlemen pursue the things that they're passionate about. Again, you'll never hear me in here bashing people for their efforts. I think that's ludicrous. I think that is just an immature and irresponsible way to conduct ourselves. So again, I'm always going to be supportive of those who are jumping into this fire, and trying to swim amongst the flames. Because again, this isn't easy. This isn't for the faint of heart. This isn't for those who are, that have no idea what's going on. For those that think drinking the fluoridated Kool-Aid is a good idea. Well, again, these programs may not necessarily be for those individuals. We're trying to keep the conflict to a minimum. Again, I love entertaining questions. At some point here in the very near future, like I was saying, once we get a little bit caught up, I'll be drafting some of these live working documents right here, where I'll actually be sitting here for the hour or two, whatever that happens to be. And I will unmute everybody so we can actually start to correspond and actually interact together to develop this stuff. Now, again, I do have a lot of these documents coming. Again, like I was mentioning the other day, the deed of trust, that is another incredibly important document to come. The security agreement, we've had it posted in the past. I don't know if you can even still find it online or not. I don't know, but we're going to be posting it here for consumption again shortly. So without further ado, let's just get into some of this language. Now, some of this language is going to be dry. It's going to be, what's that even talking about? But again, feel free to take screenshots of this stuff as we go. This way you can go back. And again, when you read it the first time, it's always going to be a little bit confusing. It's always going to be like, oh, what the hell is he talking about? That doesn't make sense. But again, as you start to assimilate the knowledge, the wisdom, these things will start to appear. When you're laying in bed at night thinking, okay, I see why stating something or a fact in the charging part and in the stating part is important, because it's establishing the two witnesses component. So again, these little light bulbs are going to start going off. If you want all the light bulbs to go off all at once, guess what happens? You're actually blinded. It's just so much. You'll actually be feeling your way around and you'll actually lose ground. So I get that a lot. No, just give us the best, give us the ultimate, give us it all in one shot. It's like, if you only understood the gravity of it, because again, you need to be able to speak to this stuff a little bit. You got to be able to charge it. You got to be able to give it a little bit of life. Because again, the judges are probably going to ask you a couple of questions here and there. That's just inevitable. But again, don't be afraid. Don't be shy. Don't be willing to, I don't want to try. This is part of learning. Again, firsthand knowledge accounts. A friend of ours back home, he had gone to court 7 different times on 7 different occasions trying to get this stuff rammed through 2 and 3 years ago without all the little golden nuggets, procedural dynamite pieces that have really accelerated our processes and are finally getting us some of the attention that we deserve. So even though some of this language is going to be a little bit tough, just bear through it. I'm going to do a little bit of charm and I'm going to do a little bit of explanation as we go here. And again, this is what the questions are for. When I say something about, oh, the charge is this, that, and the other. Okay, Darren, can you just explain that little part a little bit more? So again, that's what the question, that's what the chats are going to be for. Okay, so here we go. According to this text or this manual, anyway, in the fifth part of creating your bill or your petition, this is the charging part, and this forms the last part of the premises being the environment or the experience that we're trying to convey or present to the judge for his consideration. And the said defendants sometimes pretend that I'm not entitled to what it is I'm about to do. They would pretend that I'm not entitled to the relief, et cetera, et cetera. So this is how this continues. And whereas your petitioner charges the direct contrary thereof to be the truth. That's a pretty loaded statement right there. That's a good one. And charges that. And further charges also, this is going to set out the preliminary steps or the preliminary wording that's going to properly get the stage set for us. The judges want to see an organized fashion. The judges want to see you kind of following court procedures, court rules. This is actually important. Believe me, back in the day, we try to bust the door open, come in with the way we think this should be done and the way we think this ought to proceed. And guess what happens? You don't get very far. Again, that's why I kind of laugh at the belligerent claimant stuff nowadays. Yeah, I know the belligerent claimant, the squeaky wheel gets the grease. But you know what? If you want to put your hand up or you want to step forward, that doesn't mean you have to do so with an asshole attitude or a combative tactic or strategy. Let's just calm that down. Let's stay reserved. Let's stay calm. Let's stay present in the moment. Trust me, you get the fruit much quicker when you use sugar than salt. Okay. I'm going to go into a minute here about what is it that we're actually charging. That's going to be an important part of this discussion. But let's just continue here for a minute. This part consists of statements expressed as mere pretenses of the defendant's each chief fact that the petitioner knows or firmly believes that they are going to try to establish as a defense. And we're going to charge ahead of time. We know they're going to say this, Your Honor. So here, let's just deal with it right now. So you're literally taking their statement away. You're literally taking their energy away. You're giving the judge the heads up on what we think is coming. And again, having done this for 10 to 20 years, we know that Meads versus Meads, which was started in Alberta, Canada, based on some of the proceedings that Dean and I and other loved ones were ramming through the courts here in Canada. Okay, so Meads versus Meads, although it sounds on the surface like it is smashing sovereigns or man and a woman who are trying to express their equitable interest, although it sounds like it's smashing us, believe it or not, once you actually look at that document a little bit deeper, it actually opens the doors and it actually tries to direct us. It actually shows us a little bit more kind of a hey, do it like this, don't do it like that. And again, that took us years to actually figure out. But that judge was actually doing us a little bit of a favor by smashing us publicly or making us sound like we're lunatics. Well, as a matter of fact, we're trying to do, I charged the direct contrary to be the truth, Your Honor. I was a lunatic or deemed to be a lunatic before, and now I'm actually trying to come forward and settle these matters. So again, use some of these things as tools to better our understanding and our wisdom and our direction. So here we go, and we're moving forward. So we're literally preemptively trying to take away the defendant's charge. They will try to establish against us in opposition of our facts to show that such pretense or what we're doing is false or useless. Okay, well, let's enter the definition of a word pretense real quick here. Pretense, an attempt to make something that is not the case appear to be true. Well, that's interesting. His anger is masked by the pretense that all is well. So a pretense is this, something that it's make-believe, it's an act, it's putting on an act, it's acting, it's dissembling, it's shaming, it's a sham, it's fake, fining, simulation, falsification, dissimulation, and inversion, imagination, self-deception, play acting, posturing, posture, posing, pose, can't. What is that one? Attitudinizing. Oh, that's a cool word. Okay. Deception, deceit, deceitfulness, fraud, hoax, fraudulence, fabrication, duplicity, artifice, subterfuge, treachery, trickery, dishonesty, hypocrisy, and so on. Again, I got 55 of these things of what the word pretense means. So we're actually getting rid of their pretense. We're actually saying, no. They're going to come at us with falsity and lies and opposites and garbage. So we're going to take their steam away, Your Honor, by giving you what they're going to say. That actually, what does this do though? This allows the judge to make a decision quicker, is what it does. You actually do that. Can you imagine rolling into a court case where you do the speaking as the plaintiff and you can do the speaking as the defendant? If you had that power, what do you think the end result here could be? Well, Your Honor, I know the defendant is going to say this, that, and the other. So therefore, here it is. And here's my arguments, or here's my claim in opposition to their defense. The judge is going to look at that and go, okay, well, that's sufficient. So, okay, so going back to the structure of above, what it is we're talking about, appending as many distinct charges only to each pretense as the pretense seems to require to render it nugatory. So we're going to set something up that establishes their defense, or the words about to come out of their mouth, as a nugatory. What does nugatory mean? Here's another definition. Enter nugatory, which first appeared in the English language around the 17th century. It comes from Latin adjectives nugatorius, and this is ultimately a derivative of the noun nugae, I guess, or nuga, or something like this. It means trifle. It means vain, idle, empty, and hollow. Nugatory means without worth or significance. Your Honor, the defense's statements are nugatory. They're without value, but they're without significance because, then give them a little reason why. That is going to really start to establish, the judge is going to see, well, okay, this petitioner, this particular plaintiff, they've got some serious substance coming. And now I'm not suggesting you need to use these words. I'm just suggesting that these are the words that the book used that I just pulled from. And rather than, alter that, I'm just going to define what it is that some of these guys are talking about. So I know, we used the word append or appending there just a moment ago. This means to add something as an attachment or a supplement. An appendix to my affidavit is my adverse claim, right? It's an appendage. Something that's like a finger, or it's attached. It serves a purpose, and ultimately it is part of our story. So these little guys, these little nuggets here, they're pretty important. So if the petitioner knows of no defense that the defendant will be set up, then he should still state something such as, and the said defendants sometimes pretend that your petitioner is not entitled to the relief sought by his bill or petition of complaint, but only to a portion of such relief. Whereas, okay, let's go over that for a second. The Attorney General's office or the Minister of Finance or whoever it is that we're going to name as a defendant, if need be, don't get me wrong, sometimes we can actually suggest, Your Honor, I don't know who the defendant is in this particular case, so who am I going to put as a defendant? You know what? Put John and Jane Doe. And now, based on what it is for substance in your pleadings, the judge will know, okay, we/you need to send notice to, and then he'll actually tell you which party needs notice. So that kind of saves our ass a little bit, because don't get me wrong, loved ones, I've scratched my head on a number of occasions over the years. Okay, who is it that I'm actually sending this to? Am I actually sending it to the Receiver General of my country, this country? Am I sending it to the Attorney General through the Deputy Attorney General's office? Is this one going to the judge? Is this one going to the Postmaster General? Like, where is this one going? So again, depending on what it is you're trying to do, that option, we can fill that one in. Okay, so they're suggesting here that, yeah, he might be entitled to get out of a speeding ticket, Your Honor, but he's not entitled to access his trust accounts or his life estate. So what we're suggesting here is, of course, we're entitled to receive or be entitled to access our minor converted account switched into a major securities account. Again, we're suggesting we're entitled to all of it, Your Honor. We're not entitled to a portion of it. I don't care about getting out of the speeding ticket. I want to make sure I never get pulled over for speeding again, because I plan on doing a lot of it. Because if it doesn't bring harm or injury to another, what public entity is going to suggest that I can't do that? Wrong. Now, again, this is going to be kind of conflicting, where if you've done any research and any digging into statutes and legislation and stuff, you'll see in the odd pretense, there you go, you'll see in the odd circumstance where the public interest still trumps private law or private stuff. You know what? That's the public version of private. Can you imagine putting a private property sign on your front gate, but when you're a public citizen and you're just a renter, is that situation or is that circumstance actually private? No. It's all public. This is part of the scam. They wanted us to think we were enjoying private property ownership rights, et cetera, et cetera. That's all bullshit. As a public citizen, you're not an heir to any property rights. You don't have the right to put the private property sign on your front gate, believe it or not, unless you've done something in the background that changes the interest of the parties. Notice change or disposition of interest of the petitioner, of the defendant, yada, 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 yada. This is one of the primary defenses that you're going to want to bring into a counterclaim. Hey, I'm being sued for such and such, or my house is being foreclosed on, or, Child and Family Services is trying to take my children away, whatever the story is. I'm trying to get over a speeding ticket. Remember, the court is presuming that you're in that debtor position. The court is presuming that you've volunteered to pay such public debts. The court is in the presumption such and such and such and such, and will proceed until we disclose a better claim for equity or a better title. This is what the notices of interest or the notices of disposition of interest are doing. Your Honor, I was deemed to be the debtor. However, there's been a disposition or a change of the position of the parties. Now I'm coming as a creditor, or now I'm coming as surety, or now I'm coming as a subrogee, or whatever it is, whatever title we want to massage into that statement. Okay, so moving ahead. And whereas your petitioner charges the direct contrary thereof to be the truth and charges that, what are we charging? Let's concentrate on this because it's to come further on in this document. Let's charge that the defendant is in possession of a certain something. And because the defendant is in possession of a certain something, I'm thereby entitled to a certain something else in exchange, return, refund, report, whatever. However you want to structure the nature of the proceedings, we'll go over that. But point being, again, something has changed, something is different now. And then and then state in the charge some act, deed, or writing of theirs, or one of them, which manifests of itself some ground for belief that they have acted clearly as if the petitioner was entitled to and ought to have the relief he prays, or some portion of it. Okay, so what is that actually saying? So believe this or not, it is implied that when they granted us this little certificate, okay, that is an act, is it not? That is a deed, is it not? That is a writing, is it not? Is it of theirs? Yep. Does it manifest of itself some ground that we could believe or know that we can now come in and we are entitled to do something with it? They wouldn't have put it in our possession if we weren't meant to do something with it. Remember, we all used it incorrectly, right? When we took it, we personally identified as it, and then went on to make those applications at the federal level for all those other social programs that we've talked about every episode here thus far. So they put us in possession of something. They knew we were going to do something with it. And believe it or not, by us not doing something with it is actually still doing something with it. So there's no excuse here for ignorance. There's no excuse here for, oh, I didn't know. There's no excuse here for, I made a mistake. So I would like to now come forward and correct that. Some statement to manifest this charge is nearly always possible to be made, as the defendants, or some of them, never can have acted thoroughly with due diligence throughout the transaction stated. Well, what's the transaction stated? The fact that evidence was entered into a record, they spit out a certificate because they had to create an account, and because of that transaction, Your Honor, we're in the particular circumstance or nature that we are right now. I am in possession. Look, I have the thing. Clearly, some transaction has occurred. Something has happened. Otherwise, I wouldn't have this, correct? Pretty simple. So, but it must have been committed. They did this thing. Mom and dad did something for us, and then they did something. And, it must have been an act of negligence or forbearance or writing. While we're talking about that, let's talk about forbearance real quick. Enter this definition. It means patience, self-control, restraint, and tolerance. Forbearance from taking action. So what are we talking about here? They would have acted with some type of forbearance. They would have realized I was a debtor, because that's what the record states, until we come along and change it. So really, until you change the record, or until that actually materializes, and until they have evidence or proof of that, would they still try to pull you over and give you a speeding ticket if the record shows do not detain? So what this is suggesting is, until we have changed the record, once we do change the record, they would have been acting with some kind of negligence, or they would have been acting with some kind of misinterpretation, because clearly once the officer punches into his computer, hey, leave this individual alone, they would have. But they're not. They're still attacking me. They're still trying to attach liability to me, right? So again, this is just another word that was in the definition that I thought that we would throw at, take a peek at it. So something must have been in their possession. Something tending to all appearances. What is tending to all appearances? Does the birth certificate tend to your appearance? Yeah, it does. It's helping to set the stage for them to attach liability to you because we volunteered to pay it, right? Something tending to all appearance to show the petitioner is entitled to relief. Does the very nature of being in possession of the birth certificate entitle us to some type of relief? Yes, it does. It will entitle us to relief, or it will entitle us to punishment, right? A curse or a blessing, depending on how we used it. Because you got the thing, if you steer the boat correctly, it is your voucher. It is your coat check ticket. It is your get out of jail free card if you use it correctly, if you discharge a former interest in it and then charge it with a different interest. Can you do this vocally? Yes, as I've said almost every day now on every episode. Yeah, you can do this, but I'm suggesting just get familiar with doing it on paper first, give yourself a structure that you can memorize, and then go play with the police, the judges, the courts, yada, yada, yada. And again, this is the whole pretense of what we're trying to do here. Although this isn't acting, this is the real deal, okay? If even the last mentioned above sources do not exist, if you don't think that the defendant is going to have any defense to what you're going to say, Your Honor, this is so clean cut. This is so simple. This is so perfected. This is so diligently inquired of. I'm confident, Your Honor, that I can proceed. And if there are any questions that you have for me, please, I'll entertain them because I'm here to do equity. Again, having that type of an attitude. Okay, so to supply a ground for a charge, you got to furnish a ground to anchor a charge. And this is my wording right here in brackets. Grounds and charges. Sounds pretty electrical, doesn't it? Once you have an understanding of how electricity or currency flows around, this will actually all start to kind of make sense. You got to provide the ground. There needs to be a grounding rod, literally, maybe you connecting to the land so that the dirt, the earth, can ground a charge. Okay, still, the petitioner should charge some supposititious fact. Oh, there's another fancy word. What does that one mean? It means substituted for the real thing. It means it's not genuine. So it's actually saying right here that the petitioner should still charge something that substitutes for the real thing. Okay, what could we possibly be talking about there? A couple of scenarios. Maybe we're saying, hey, for the time being, I'm going to attach a photocopy of my birth certificate just to get the ball rolling. That is what? It's not the real thing. It's not genuine, but it still is going to convey information. Because again, you may not want to send the original until you hear back from the court. You may not. It doesn't matter. We're all sending the originals at the end of the day anyway. But again, this was just a word that I wasn't even sure of what the hell that meant an hour ago. So here you go. That's what that one meant. So the fact that these facts having such relevancy to the case and so likely to exist, again, this is where we can rely on a little bit of presumption. The court can presume that I was the grantee of this particular certificate. Why? Because I'm in possession of it. I've now perfected some interest in it. That makes me the grantee. Once the court operates on that presumption, now they can operate on a presumption that, okay, well, are you coming as the grantor? Yes, Your Honor. What is it you wish to grant? I'm thinking an undivided legal interest attached to that certificate of security, Your Honor. He's going to know exactly what the hell it is you're trying to do. That just created the financial asset. So again, Are you coming as the grantor today? Sure. You know what his next question is going to be. Well, then who's the beneficiary? Because this could happen. If you're coming as grantor, are you leaving the door open for the beneficiary? What if the judge swoops in and says, well, then fine. If you haven't declared or specified a beneficiary, I'll take that position. Ugh. What just happened to your court case? You just blew it. When you show up as the beneficiary, the judge might say, okay, well, if you're the beneficiary, Dean, who's the grantor? Where did you get this thing from? Well, that was me the other day acting in that capacity, Your Honor, when I drafted the entire deed of trust, when I drafted the security agreement, when I drafted the administrative agreement. That's me acting as the grantor, setting the stage for events to come. That's why the grantor has the option, the ability to go in and amend. We reserve that right continuously as we go throughout this process. We're always, again, I reserve all rights. Well, rather than say that, why don't you say exactly what it is you wish to reserve? Your Honor, I wish to reserve the right to amend my pleadings, my affidavits. That is going to be a non-ambiguous statement. It's just going to help to tighten things up, to show that the judge is competent, to show the judge that you know some of the things he's going to throw at you. And when you respond quickly and with a smile on your face and with certainty and with foundational strength, he's going to look at you and they know right away whether you've done the due diligence or not. This isn't about, oh, I watched a Darren or Dean or a Chris video, and now I'm going to submit some information to the court to try to get this ball rolling. No, it's actually going to show that you have command and control of your own proceedings. As Carl Lentz used to accuse us of throwing spaghetti all over the kitchen. Okay, well, that was fun back in the day. But it got to the point where, okay, now that the kitchen's covered in spaghetti, what stuck? What didn't stick? Again, that just created a nightmare. So I do agree with Carl, but you know what? Back in the day, we were so desperate for any remedy, we were just letting it all fly. And when we would deal with how the cookie crumbles to try to reverse engineer it and figure it out. Well, you know what? Again, that presented a lot of headache, but it also solved a lot of problems for us at the time, really. Okay, so after the last charge, okay, did I get that right? No, hang on, I got a little bit more here to go. Okay, so after, so having such relevancy to the case that you're actually bringing in these little minor facts to support big facts, okay? So whether that it cannot be thought on perusal or impossible or impertinent. That means, hey, if A and B equals C, then chances are D and E and F are coming, Your Honor. It's just, that's how the system works. And which, when your questions are answered by the defendants, they must afford some valuable type of information to aid your case. This is where, again, I was mentioning the other day, this is where they're going to be very hesitant to have your specific questions, which I'm not dealing today. I think we're going to talk about those tomorrow. Give me a chance to go back in the notes. And I think the questions I was mentioning the other day, there's about 10 or 12 of them. When you line up these specific questions perfectly, wow, it opens up Pandora's box. The judge is not going to want Pandora's box opened up on a public record, having the Attorney General or the Minister of Finance actually enter these or actually answer these questions. Because all that's going to do is create a menu of items 1, 2, 3, 10, 12, 13, how to get the remedy we're after. They would rather you just get your remedy and get out. They don't want to expose this because it's actually embarrassing. The Crown doesn't want themselves to be, seen as acting as dishonorably or with malicious intent or these things of this nature. The judge is going to seal your case immediately. The judge is not going to want this stuff to be disclosed or exposed, however you want to phrase it. Okay, so we're going to structure those questions so that it extracts vital information if the way we're bringing this case, Your Honor, is insufficient or if it's inadequate, right? So again, we're protecting ourselves. Your Honor, I'm bringing it to the best of my abilities. And if I happen to fall short, I have a bunch of questions in reserve that are going to answer all my deficiencies. And again, when you see the way these questions are laid out, you're going to say, okay, I see what the hell Darren was talking about. It's excellent. Moving forward. Okay, and we're charging further that there are now in the separate possession of each of the defendants. Again, none of this is my words. I pulled this directly out of a book. What could possibly be in the separate possession of each of the defendants? Now, again, that could just be a singular defendant. It could be the Minister of Finance and the Attorney General. It could be the Crown, generally speaking. So All that we're saying here is they are now in possession of something and that it is under his control. Well, Darren, you're talking about we want the control. Why are we giving them control? Okay, two controls here, correct? We control the equitable side, let them control the legal side. The equity trumps the legal, right? We got to maintain some type of control. But now that you're not in possession of the legal interest, you've just granted it, you've granted an undivided interest. That means no portion of it. You've literally granted, delivered, sent, attached, transferred that entire thing to the crown or to the state. If you're in a country that Her Majesty the Queen does not have control over, again, just send it to the state. That's essentially what's going on here. So, well, I spelled deeds wrong. I see I got deads here, but anyway, each of the following defendants or under his control, any writings, deeds, books, papers, memoranda, letters, copies of letters, receipts, tickets, vouchers, printed papers, and papers with writing thereon, whereof copies have been sent as letters or notes, which have been used as, or one or part of one writing, deed, book, etc. So we're actually suggesting, hey, something tangible, a writing, something written on, something of significance and importance, something that maybe explains a disposition of the interests of the parties, maybe an agreement, maybe a deed. This thing is now in some other party's possession. Okay, really important. This thing is having relation to or making the allusion to the matters in question, or someone or more of them, whereby the truth of the statements and the charges mentioned above, or some of them, would clearly and fully appear. And each of these writings, books, doings, as mentioned above, in the possession or under the control of each of the defendants, or one of them, mentioned above, your petitioner, I spelled here wrong too. Your petitioner here seeks from each of those defendants a descriptive and full set of particulars, well arranged and framed, so as to form part of an intelligible schedule with all the proper dates and descriptions therein distinctly set forth, so that the parties, you really, and matters alluded to by the contents of the said schedule may be plainly and succinctly manifest. What that's saying is, hey, if they're not going to grant me the thing I'm after at the moment, Your Honor, which is technically an indefeasible title at the moment, if they're not going to grant me that, Your Honor, they're going to have to answer all these questions precisely, succinctly, with precision, lay it all out, right? They're going to have to answer. They're going to have to provide me with the remedy that I'm seeking. If I've kind of thrown a dart at the dartboard and I hit the wall, missed the dartboard altogether, mom's going to be pissed when she sees the hole, whatever. They literally have to now provide answers to your questions. It would be unconscionable for you to bring your proceeding, your motion, your application, your petition, your requisition to chambers and then have the judge literally not answer any of your questions. Doesn't happen like that. Whether a fact is to be stated in the stating part or the charging part of the petition may be decided by the following criteria or criterion. If it is a fact fundamentally material or important to your case, it's actually essential to it. And again, that's not my words. Actually, whenever you see the word actually, does that mean you got someone on a set of strings? You're like the puppet master and they're actually doing something for you, right? The little wooden guy, pressing buttons, switching things in the background, discharging debt for you. Something is actually essential. That's actually touching on the subrogation component of our entire process. You used to act for this thing. You've granted that ability away. Now some other actor, some other character has to now stand in action when you used to be. You are now vacant. Your position is now being substituted. There's a new player. Maybe it is a player from, the Crown. Maybe the Attorney General steps in and starts administrating your charitable trust for you. If you're not capable of doing it, will he do it? Absolutely. And that's one of the answers I had to someone mentioning on one of the posts I did on Facebook not long ago, where, Darren, I thought that the administrator, the Attorney General, would step in and administrate your stuff for you. Yes, of course they will. But you got to give it to them. You got to put them in the position to do that. Otherwise, what do you got? Not a lot. And as a matter of fact, I'm going to allude to this here right now. one of our initial correspondences we had with the Attorney General's office here in this particular country, the agent or the lawyer acting for the Attorney General literally said to us, and I'll cut and paste it and I'll show you. It says something like this: because there is no written agreement between yourselves and the Attorney General's office, we are forced to proceed with the following. Okay, we'll back that up. What did he just say? Again, until I have it for you, just bear with me. This is what it said: because there is no written agreement. That tells me, and again, I don't think you got to be an equity wizard studying this stuff for 40 years to figure this part out. Because there is no agreement, does that sound like we should be creating one to avoid a potential court case, to avoid a conflict of interests? Maybe we can settle this thing properly if you just create the agreement. Remember, by an implied agreement, our rights, liberties, beneficial interests in property are being held by another party. Why? Because we were absent to the first agreement. It's like mom and dad set it up and then they never finished it. They walked away. So this thing is just dangling. It's left hanging. And after a certain period of time, this thing that's left hanging puts the crown, the state, in a position where they can now swoop in, act as literally grantors and beneficiaries for your best interests. Yeah, right. Not at the time. Later on, once you fix it, sure. But in the moment, the benefit of taxation, it doesn't feel very nice. So all they're doing is manifesting income in your absence. Because can you imagine? You can literally come back when you come back to life and you present your case, when you report a finding. Your Honor, I found a abandoned interest attached to this security, and I would like to report it. I'd like to return it to the rightful owner so that they can go register that event at Land Titles, where it appoints them to be new trustees, because I know by default, I was acting as the trustee and the surety for that. You see what you just did there? Pretty dynamite stuff when you actually get your head wrapped around it. Okay, so moving forward here, and that this fact is material to your case, actually essential to it, beyond all doubt. Is there any doubt that you're entitled to your birth certificate? Of course not. Come on, it's laying right there, it's right in front of us. Or of its very consistence. It should be in the stating part, but not otherwise. So it should be in the stating part and it should be in the charging part. And this is why. As to the charging part, the equitable ground for relief, again, equitable ground. Where is the nearest ground when you're lost at sea on Her Majesty's ship as a janitor locked in the dungeons sweeping the floor? Where's the land? Where is it? If you go up on the deck and you take your little telescope and you're looking around, okay, doing the Christopher Columbus thing, where's the land? The closest land to you at that very moment is you. You are walking dirt, right? Yes. So when you start to attach your interests to a particular voucher or a particular coat check ticket, that is enough to dispose of a former interest. Literally, dispose of it. Get rid of it. It's changed, it's mutated, it's been recycled. Some other party is now interested. They have to be. Why? Because they put you in possession of the certificate that opens the door for you to come later. This is the transaction I was mentioning earlier. Okay, so this equitable ground for relief on your part, it must appear in the stating part of the bill or your petition. For if it only appears in the charging part, the bill or the petition will be demurrable. What is demurrable? Demurrable is a pleading, a petition, or an application, or requisition, or any of those things, is said to be demurrable when it does not state such facts as supports the claim or prayer for relief. You're putting it forward. So if you don't attach sufficient evidence to what it is you're trying to claim, the Attorney General's office is going to come around or come along and bounce it. He'll kick your claim out. Why? Because it's not complete. Remember, equity will not perfect an imperfect gift, which is actually technically saying equity will not complete your incomplete process. You need to do it. Okay, so demurrable kind of means it's defeatable. They can come in and just destruct it. They can blow it up. They can not even answer it. They can say that your pleadings are without merit. Your pleadings are without material fact. your pleadings are not good enough. Okay, so there's another one. Demurrable also means to voice opposition, to object, to suggest at an objection. It's archaic to delay. It's saying you better get your shit in order, or again, come in with a scrambled egg mess and do your best. Again, equity aids the vigilant. As soon as you start trying to do some of this stuff, we've heard of incredible stories where the judges will literally come to your immediate aid and assistance when you do it correctly. Here's an awesome story. Again, an esteemed colleague of ours down in the United States forwarded this story to us. An old lady rolls into court and says this, Your Honor, due to my frailty, due to my age, due to my poverty, at this time, Your Honor, I'm just unable to make my mortgage payment. You know what the judge did? He grabs the mortgage and he goes, and he ripped it up right in open court. Do you see the difference in the defenses? We used to say, Your Honor, I'm the grantor beneficiary of that instrument, and because of this and because of that, blah, 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 blah. We went on this whole tirade, this whole thing. Now, don't get me wrong, at the end of the day, we did have some successes with that. I don't want to divulge too much information, but a number of years ago, I think I've actually mentioned this one on chats before, Dean helped a farmer here in Middle Canada with I believe it was a federal tax court case where Dean sent in some paperwork. I don't even remember who he sent it to, but he claimed, essentially at the end of the day, for this particular farmer, he claimed an equitable interest in one of the pieces of the puzzle. The puzzle, let's just loosely describe it as this. You got the house, you got the land the house is sitting on, and then you got the mortgage note floating in the background that could have been converted into something for your benefit. So Dean actually claimed the principal mortgage amount back. So foreclosure proceedings continue. The guy gets a checkpoint for like $1.5 million for the value of the house or the land, but he's still evicted. He still gets bounced. He still had to get out. Why? Because Dean left two elements on the table. He didn't maintain, or he didn't lay a claim to maintaining the possessory interest or use of the property. And he also left on the table, hey, bring that mortgage note back here, right? Under equitable terms of sequestration, marshaling, tracing, accounting. If Dean had asked for some of those things as well, guess what would have happened? And believe it or not, this happened like 10 years ago. This is ancient for us already. Okay, so anyway, I just want to get into another bit of a quick blurb here as to what does a charge actually mean? What is it? What is it that actually means, right? Okay, a charge is one of the methods. Okay, so that means there's several. One of the methods of taking security, like that one, recognized by English law. And again, any law that is currently governed by the banking system as we know it. In daily life business, as it is common for corporate entities to give security to lenders. Whoa, back that up. It is common for corporate entities to give security to lenders. What could a corporate entity give to you as security? A certificate. To lenders. It's almost like mom and dad lended them something. The something gives you a certificate back. And now you can do something with that certificate, again, to lenders over their assets. Whose assets? Your assets, your birthright, the inheritance. That's what assets. It's hidden. It's disguised as a certificate waiting to be converted into a financial asset. That's what type of asset. Ooh, that's a good one. Either by way of mortgage, lien, or charge in the nature and effect of a charge. So when you lay a charge is another word for a mortgage, an encumbrance, a lien, things of this nature. And it's you physically attaching an interest. That is a charge. A charge is a creature of equity. Ooh, like that one. Technically, there is no such thing as a legal charge. What? Although a legal charge may be created by a statute. And if they're going to create these statutes and they trick you into volunteering to be governed by these statutes, what just happened? Did you just come along and complete the charge? Did you just actually become the wire between the energy and where it is flowing to? Imagine you just hooked up to the what are they called? The anodes, the diodes, the terminals. You just put your hand on one of those posts, whether it's the negative or the positive. We don't really know that at this point, but you just grabbed one of these things. You're playing the electrical game. Okay, so moving forward. An illegal mortgage over land is commonly known as a legal charge. Essentially, a charge creates an equitable proprietary interest in that certificate being secured. What's being secured? Well, I don't know, call it dominion. They're monetizing our dominion. That's actually valuable. They're creating these bills of exchange and these security certificates so they can actually monetize value, turn it into currency, whether it's money for exchange or deposit or whatever you want to call, however you want to classify the money component. They're doing stuff with this charge. A charge arises when there is an agreement between the creditor and the debtor. So imagine a legal charge is created when you voluntarily agreed to be the debtor and they volunteered to be the creditor. A charge now arises. Energy now is transmutable. They can literally put that charge in the bank, correct? They can now leverage against that charge, correct? Because haven't you just promised to pay the debts of this corporation over the course of your whole life? Yes, they can monetize this. They can actually turn that into value. They have charts and tables and all kinds of, doohickeys to provide the numbers and all the ones and zeros to get this commercial system flowing. Okay. When the debt is discharged, when the debt is discharged, we're definitely going to want to dive into that a little bit more. The charge terminates, right? Okay. So the initial legal charge gets terminated. That shitty legal trust implied covenant, whatever you want to call it, terminates. Why? Because you've redirected the charge somewhere else, which means something has terminated, something collapses. Okay, is that the 10-minute mark already? Oh my God, okay, we got to fly here. There is no transfer of a legal or beneficial ownership or possession, merely an encumbrance on the asset. So again, the conditions are here: positive, negative, legal, beneficial, equitable, whatever. Those two things always exist. There can't be one without the other. The charge is in the what you do. If you don't do anything, there's no charge. If you don't charge your own estate or trust, isn't it open to somebody else's charge? Yeah. Can you imagine your charge is just a protective bubble, right? It protects. This is what the whole concept of a trust is doing for us in the background. It's protecting something. It's a charge. It's your energy being literally being placed into a particular writing or deed that can be recorded as an event in time and history for all to see or not to see, depending on how private you make it. Okay, the creditor has no right to the possession of the asset. Whoa, what did that just say? The creditor has no right to possession of the asset. That's why they're creditors, because we have possession. What happens when we switch that? What happens when we give them possession? Does that kind of make us the creditor? I don't know. Maybe do a little math on that one. I'm thinking it might. Okay. The creditor can enforce security without reference to court. Usually, well, what does that mean? Because you've made an agreement, they can literally liquefy or get you to act or perform your obligations without court. They don't even need it. What that's saying is, hey, if you don't make the mortgage payment, we're going to come take the house. And they literally don't even need court to do it. They can, in reality, yeah, they do. They still get the judge to just quickly do a quick hearing. Your Honor, sheriff, go take the house, done. Why? Because in that mortgage agreement, you've already agreed to letting them come in and boot your ass out and dispose you of possessory interest of the house. Possessory interest is an interest. Does that mean you actually have possession? No, you just have an interest in the possession. You're in possession and I have an interest in it. See, I'm not actually in possession of this certificate. They are. Beautiful. Okay. A charge is usually effective against a debtor on liquidation or administration. I'm dealing with a particular something today with a particular set of authorities, and I've asked them for a simple administrative remedy saving me the bullshit of having to go to court to get an injunction. See why administration is so important? See why Dean's been talking about administration for years? Again, Die 5, myself and Queens and others coming at us. We are training us to act as administrators and sub-administrators to avoid an entire court process. Okay. The types of assets that can be secured by a charge. Well, that sounds interesting. Generally, assets which equity recognizes as property and are capable of being transferred can be secured by way of a charge. Equity recognizes most forms of property, including property not recognized by the common law. What property is not recognized by the common law? Here's one, the entire Sedequer Trust concept, 1666, that whole thing. Legally, they don't want to recognize it. They're going to say it's repugnant. They're going to say it doesn't exist. They're going to laugh at you. They're going to say you're crazy. Trust me, I went for a psych evaluation one time during one of my court cases. I think I've talked about that online before. I'll get into that on an upcoming episode as to what, why, and why that psych evaluation was super, super important. Examples of the assets that can be subject to a charge are existing assets, such as land, goods, and intangibles, future assets, such as land, goods, and intangibles, acquired after the giving of the security. What? Giving what security to who? Isn't that kind of what we're doing? Isn't that what the adverse claim is essentially doing? 6 minutes, let's go. Giving of the security, intangibles include assets such as book debts, goodwill, what? Benefit under a contract, and rights under a trust. Hello, how a charge is created. The debtor must intend, okay, you're the debtor, remember this, you must intend to give the creditor a proprietary interest as security. An undivided legal interest is a proprietary interest. You gave it all to them, not just 99%, and you kept one just because you weren't sure. A proprietary interest is the whole thing, okay? The intention must relate to identifiable assets. You got to define, you got to describe, you got to show what this asset really is. To create a fixed charge, the creditor must have control over the charged asset. This is beautiful stuff. Without sufficient control over the asset, the charge will, if given by certain entities, be a floating charge. Again, your charge, it's enough to get the ball rolling, but you want to nail that down. And until it's nailed down, it's still floating. It's still out there. You created it. It exists. A floating charge can only be created by a company, a limited liability, something, LLP, or a farmer over certain assets. Again, this is just, they're adding context to it. What they're saying is, hey, the floating charge needs to be nailed down. It needs to be described further. The charge must be by way of a contract. Is that writing or verbal? Could be both. With executed consideration. What's consideration? Love and affection or silver. Get used to one of them, if not both. That is, the consideration has been paid or out of your possession. You've departed with consideration. Beautiful stuff. It's not just promised. It's not just, oh yeah, I will do it. I have done it. It sets the standing for you. Not on a future event, what happened right now. The requirement for the executed consideration is unlikely to be an issue because if the creditor has not made the loan, the security is not required. Who loaned who, what, and what security was a result? Right? Chew on that one for questions if you want to throw that one at me a little bit later. For a charge over land, there must be a contract in writing signed by both parties. As soon as you put your signature on the birth certificate, do you have an agreement? Are both parties present? Hello, we're making progress. The law of property. Again, a charge over an equitable interest in land must be in writing, not just vocal. It must be in writing. Does it say it may be in writing? When you see the difference between the words must and may, there's a substantial difference in the two. And signed by the debtor, you, okay? According to this such and such law of property act anyway. A charge over a patent must be in writing, same thing. A charge for cash over financial instruments and credit claims, which are claims under loans made by credit institutions between two parties, to take advantage of the benefit of the financial collateral arrangements. I've talked about financial assets. I've talked about collateral. And here's the arrangement. Here's the agreement that we're talking about. A little bit of stuff, talking about how it must be more in writing still. Charges created by companies. Company's house, unless exempt. Charges created by individuals. Again, individuals. Does it say persons? No, individuals. You're separate from the person world. Charges given by individuals over personal chattels. Is that birth certificate a personal chattel? Well, yes, it is. Usually need to be registered under the Bill of Sales Act. And amended as such. Charges over intellectual property, that's the thing as well. Charges over land usually need to be registered under the Land Registration Act, 1972, the year I was born. There's a good one. Okay, so what we're talking about here, I know I've only got a couple minutes left. Charges are a very important thing. Structuring the charts properly in your bill or in your petition is something that we need to develop. We need to work. And again, as I develop or as I show you a working court petition, you're going to see why this is important. All these elements must be laid out in a practical and in a consumable manner so that the judge can come to your aid and assistance. If you give the judge a whole mess of stuff, all unorganized and all intelligible and all just, let's not create a whole lot of work for the judge. Let's do as much of this bullshit trustee work for now as we can to set the stage to put that judge in possession of the titles, the consideration, the agreements, so that he can now act for us in your best interest. Okay. Will the judge do all this for you? Well, there's that example. That old lady, Your Honor, due to my frailty, my poverty, and my financial circumstances, I'm just unable to pay the mortgage. The judge worked with 3 elements she gave him. Again, we got to just define this stuff. We got to organize this stuff a little bit better. They expect a lot from us. They're watching these videos right now. They're watching these Zoom meetings. Somebody with power or with the ability to either help us or not help us is watching these expressions right now. They know whether we are worthy or not, whether we are acting honorably or not, to be granted the mercy, the forgiveness, and the grace that we deserve, because we've disposed of that legal person, we've attached it somewhere else, and now we're ready for our reward. Thank you, loved ones.